So what we're going to do now is the lucky bit. We've got a panel session following straight on now, so I invite my panelists, please come up and sit down, and then they will answer all the questions. So I'll just have a cup of coffee. Move this around. Oh, I shouldn't have moved that, should I? So the panel we've got here, we've got Valentina Schulte-Braucks, who's a trademark attorney at Noerr LLP, and she wrote an interesting article, Trademarks in Jeopardy, is .com old news? So we might want to see what her thinking is on that, because is .com really going to be old news, or when is it going to be old news? Dr. Markus Bahmann, who's also a trademark attorney, and he's a member of the IMTA Internet Committee, so we have something in common.
And the IPC.
And the IPC, absolutely. So we have two things in common there. And as well as being a trademark attorney, he's the managing director of .Bayern, so that's quite an appropriate person to have here. We've got Dr. Torsten Bettinger, who's also a trademark attorney, funny that. He's a member of the legal advisory board for .de and a WIPO panelist, so again, something in common with Torsten, so pleased to welcome Torsten. And then we've got Jonathan, which is wonderful because he is not a trademark attorney. So he is really the favourite person on this panel, and we all like him. He's the founder of IPRota Limited, assisting gTLD, TLD support, and he's also a member of the ICANN GNSO Council. So again, I have something in common with Jonathan, which is great. So I'll now hand over probably to Valentina, if she'd like to go. Ladies first, and say a few words. And each person will say a few words, and then we'll open up to questions and see where we get to. I think yours should kick in.
Yes, I think my microphone's working. Okay. So I'm going to start with your question, who needs to bother really to apply for these domains? And one question you touched on, risk of string confusion. So what happens if I'm aware of a brand or a trademark which is the same than mine? I'm thinking of examples like Triumph, which exists for underwear but also for cars, or others like Dove, who exists for chocolate but also for hair product. What happens if both are interested in this top-level domain? Maybe we can speak about that a little more. And then, David, you briefly touched on the Trademark Clearinghouse, but maybe we can discuss the mechanics a little further, because it's going to be one of the main workings for trademark holders to use. And then lastly, the PDDRP. You briefly touched on, but maybe Torsten, you want to say more about this at a later stage?
Okay. Thank you very much, Valentina. Markus, do you want to? A few words?
Yes, to my observations, it's a little bit difficult. First of all, we have to divide up two things. First thing is the question whether to apply for my own TLD as a brand owner. And the second question is, which is coming far behind this first question, is how to protect my own brand within the process of those approximately 1,000 new gTLDs. I say that this topic is a little bit later in history, because the protection systems, protection systems for the IP rights are commencing a little bit later. And the first question has to be resolved until the 29th of March, we heard previously.
Thank you.
Two topics.
And Torsten?
Yeah, David, you mentioned quite a lot of topics. It's difficult to decide whether to talk about the right protection mechanisms, or whether the question who can apply, who should apply. May I comment on the URS, maybe, on the Uniform Domain Name, Uniform Rapid Suspension System?
Do you want to do that now or later? Or when?
Oh, maybe now, I don't know.
Yeah.
Yeah. Maybe just a few comments. You mentioned that it should be regarded as a valuable complement for the UDIP. I completely agree with that. The standards, the substantial criteria are very much rather identical with the UDIP. The main advantage, the main benefit for the rights holder is that the URS will be much more quicker and much cheaper than the UDIP. A great benefit for the trademark holder will be, of course, that the decision of the panel will not result in the transfer of the domain name, but in the suspension of the website for which the domain name is used. That is an important advantage for trademark holders, I think, because in the past trademark holders were forced to register thousands of typo domain names, register them and keep them in their domain portfolios. Now they have the possibility to prevent the use of domain names for a certain amount of time. The problem, of course, will be that the suspension will last only for the balance of the registration period. So the difficult question will be whether what happens after the registration period ends. Will then, when the domain names will be available again, will they be registered again? That's a problem of the US, and I think that's the limit of the scope of the US.
Okay. Thanks, Torsten. And then Jonathan.
Thanks. A couple of opening remarks, really. I suppose it's probably important to. I know you positioned me as not a trademark specialist or not a trademark attorney, and I think it's important for me to recognise, well, personally, to just describe to you that my background is in domain name management services. I've worked for many years in the, if you like, the corporate brand protection area of this industry with a company called Group MBT, which many of you all know as NetNames. And I think probably striking about that in many ways is NetNames was, as some of you may know, taken off a publicly quoted position on Friday by a private equity buyout. What's significant to me about that is that NetNames has 50% of its business, or thereabouts, in corporate name protection. And so there's clearly a recognition by someone, rightly or wrongly, that this business is here to stay from a domain name industry perspective. And I feel obliged, given my own experience with that business, the current business I'm involved in, and also my long-standing non-executive position with affiliates, to present a sort of industry perspective on this. And for me, there are a number of facets to that, and it's very easy to see this as this program that's been so diligently and thoroughly worked on for years by many specialists as solving a lot of problems, which of course it does. But it's not as fixed and as firm as it might appear. So although something like the clearinghouse is the bedrock of the whole system, there are nonetheless many opportunities for, there are both mandatory protections built into the whole system, but there are also many opportunities for flexible design in terms of rights protection mechanisms at launch and on an ongoing basis, providing the mandatory mechanisms are met. So it strikes me that there's some area for discussion in and around implementation, and while David rightly focused very, very much on the brand owner perspective and how there are many industry participants in here who will be and both brand owners and generic TLD operators who will be thinking about how to design the launch and ongoing operation of their TLDs, and rights protection mechanisms are a fundamental thread to all of that, and there is scope to work with some flexibility in all of that.
Thank you, Jonathan. Well, we can open up to questions from the audience, and if you've got any burning questions on anything to do with the brand protection or what we've covered, please do fire away and make use of this wonderful panel. And you don't get to go to lunch early if you don't have any questions, by the way. There should be a mic coming in. Do just introduce yourself. So.
Yeah, hello, my name is Yannick Skov, and I also try to consult for companies on whether to apply for gTLD or not. So my question to the panel would be, I'm familiar with the fact that there is this string confusion objection. So if I think somebody else is applying for a string visually similar to mine, and the panelists have said, well, that's not a problem, and I want it to be a problem. But what if the panelists, and here's the question, what if they decide that my brand is either identical or visually similar to another brand, so I end up in a contention set, but I don't want to? How can I object to that decision?
That's a good question. Kurt, any answers? Does anybody on the panel? I don't have an answer to that one.
But there isn't.
Can I sue ICANN, or what should I do?
Well, you could.
Isn't there a dispute?
Suing's always the answer we don't want to hear, but...
Yeah, you should write to the new gTLDs mailbox that I had in my home. No, so what'll be good is not only the people in this room will know the answer, because there's some depth to it, but others that are interested in applying will learn too, and it's really a good mechanism.
And if you get your question in quickly, we might have the answer before the end of the panel session. So. Other questions? You don't want to have to listen to all my questions I've got stacked up, so hopefully we'll get a few more. 2 more there.
Hello there. My name is John Tagg. I'm a trademark attorney. I represent Elsevier Properties in Switzerland. Well, basically my question is very straightforward. Which is the best way and probably the cheapest way to protect a portfolio?
Well, I think I've got certainly an initial thought on that, and that, I mean, the history clearly has been one of a prevention is better than cure argument. You can secure a portfolio of names perhaps more cost effectively, or at least with a lower amount of headaches, and there's this balancing, this commercial balance between securing them and defending them via post-registration defense, and the barriers have been brought down, as has been talked about by the URS, but ultimately the question remains of this is such a radical shift in terms of the landscape and the scope of the landscape that it really throws into question the whole mechanics of a defensive registration approach. One of the other issues that hasn't been perhaps as widely aired as might be, you may be aware that in the current XXX Sunrise, it's not the conventional defensive registration anymore. It's actually a permanent exclusion of the trademark term from the registry. So the question there is, and that's an opportunity available, as far as I understand it, to any registry operator. It's mandatory to use the clearinghouse and use it for specific functions, but the detail of what the implementation of those Sunrise mechanisms is open. So there is scope for the landscape to still shift quite substantially in and around issues like defensive registration. And clearly the presumption has been, with these new mechanisms in place and the comprehensive work that's been done, is on costs going down for brand owners. But that is not yet guaranteed. Just because the registries are using the clearinghouse, for example, doesn't mean that the registry operators couldn't charge relatively large amounts during Sunrise in spite of using the clearinghouse. So there's some scope for movement in all of this still.
Anyone else want to pick up?
Yes, I would like to add to that. So first, you should, of course, take a long, hard look at your trademark portfolio, and for the trademark clearinghouse, you should use word marks to put in the trademark clearinghouse. So if you're a company and you have a figurative mark, and there's a word element in it, you should try to make it a word mark. Yes. And then also you should contract a domain surveillance system who tells you, beyond what the trademark clearinghouse will make available to you, when there's domain names that are similar or typo squatters that are registered, and so that you will have a very fast information. And then finally, if there's any key second-level domains important to you, so if I register .bank and you're Deutsche Bank, you may want to register Deutsche as a second-level domain to prevent further, prevent litigation further on.
Thanks, Valentina. Do you want Markus? Go.
Probably something you can do before that, before the registering of your trademarks in the trademark clearinghouse, is to have a clear look at the process, what's going on right now. Because there's one date which was not mentioned today. I think it's still in the program that 1 month after the end of the registration process or the application process, all of those applicants are published. So if you have the knowledge about who is going to apply for what, you can manage your trademark portfolio probably in a better manner because you know where to put your stress on it. So first hint of me would be to put an eye on the process, which is what is going on here.
I highly agree with David, where the problem is not on the top level domains, it's on the second level domains. That's where the problem is going to come up.
But the problems are different. If you are consulting a pharmacy, someone from the pharmacy industry, and there will be a .pharmacy, you will have different problems than if someone is applying for .toys, and you are consulting someone from the pharmacy industry.
I think to follow on that, the key thing for me is one size doesn't fit all today in the where we are at the moment, because we've got clients who have over 30,000 domain names defensively registered, and we've got clients who've got about 100 defensively registered. So it depends is the answer to that, and we've got a whole different number coming through, and some clients may continue trying to register defensively. It may fit for them, it may work. The brand owner has 30,000 already, may think, to do that in another 1,000 across all of those, it just doesn't add up, so they have to change strategy. So again, one size doesn't fit all, and that's where it's certainly going to be interesting to see how brand owners deal with this going forward.
Certainly just a thought. I mean, this is some form of clearly hierarchical decision-making, and without stating the screamingly obvious, the first stage is to decide whether or not to apply for your own TLD. But the second is to some extent, is to decide to what extent those marks, and following on from what David said, are included in the clearinghouse. Because my understanding is that the clearinghouse will be expected to accept word marks, but also other marks that constitute intellectual property. So there is an opportunity to insert a range of other marks other than simple word marks into the clearinghouse. So that's the first step of your defensive registration. And then to understand how the registry operators might implement based on what's in the clearinghouse, and arguably to influence registry applicants now as to what kind of rights protection mechanisms they put in place.
Okay, I think we had another question in the middle there as well.
Hello, Carol Ann Lindley from Kilburn and Strode in London. I'm asking about the timing on the clearinghouse process, because whilst you might have 500 of the gTLD applications in, I think you're going to be looking at thousands of marks potentially registered at the clearinghouse. Can I ask how the panel thinks this is going to be managed in terms of the timing process? For my clients, for example, I foresee at least 100, 200, and I'm one amongst many.
Right, I can kick off on that, and Kurt, correct me if I'm wrong, that at the moment there's no provider being chosen for the clearinghouse, and there's no RFP out there as yet, and if something appeared today. You always say that with the ICANN world, and suddenly something's appeared overnight on the ICANN website. So when I last looked, which I think was yesterday, there was no RFP out there for trademark clearinghouse. So at the moment we don't know, but if anyone else wants to add on to that.
Probably I can add something. I had a dinner with Rod Beckström on Thursday evening in Berlin, and I asked exactly the same question. And the answer was, well, we get prepared for the process, and we are looking for someone who is going to run the trademark clearinghouse, but we have no decision right now. So this was actually last Thursday. So No, you don't. If I get you right, it is not the question how many applications will there be for new gTLDs. You only have to register the trademark once at the trademark clearinghouse in order to be secured in the sunrise period of all of the processes.
And again, I mean, in the real world, obviously, it's lovely to have this up and running now, but, you know, we've seen the last applicant guidebook, the final version, last week come through. So, you know, to be fair to ICANN, there is a little bit of time, and ICANN can move quickly. So I imagine these RFPs, again, Kurt, if you'd like to say anything on this, but I imagine these will be going out fairly soon, and we'll end up in a situation where we've got the clearinghouse provider in place, you know, within the coming months. But, I mean, if, Kurt, you don't want to say anything on that, please do.
Is there only one microphone? So I want to turn it around in the form of a question. So first, yes, an RFP or an RFI for a trademark clearinghouse provider will be out in a matter of days. That we think is pretty good. So if the first registry starts operations really in, say, 2013, early 2013, how many months before that, you know, do you think will be required for you to register names? So, you know, that the trademark clearinghouse is in place to register names. You know, is it, if the trademark clearinghouse opens its door 4 months before or 6 months before, 3 months before, is that enough time? We think that, you know, we have to just about the end of 2012 for the trademark clearinghouse to open its doors, publicizing along the way that it's, you know, what its rules are, and then trademark owners will have time to put names in before the first registry becomes active in 2013.
Olof and then Peter.
As Olof Nordling, I can as well. And well, while the microphone is in my vicinity, I just wanted to dispel one of the little cliffhangers that was up there concerning the finding of confusing similarity. And as anyone that has really read the applicant guidebook should know, there is no appeal to a finding of confusing similarity. Just to make that really clear. But we wanted to keep you on your toes for a bit.
Thanks, Peter Dengate-Thrush. I wanted to completely agree with Kurt's answer in relation to the clearinghouse for trademark holders putting things in. It's when the registries go live that becomes important. But just to add, Kurt, to that, the people who are designing answers to the registry back-end questions need to know about the clearinghouse much sooner than that, so that we can explain how our registries are going to interface with it. So we do need that information as soon as possible from that end. Thanks.
Thanks. I've probably got one question which I'd throw out to the panel and the audience really on this, and talking about a rights protection mechanism, the URS. I'm interested to know how many people think it's a good thing that this ends up as a suspension of the domain name rather than a transfer of the domain name. I can probably point to some discussions on that later, but I'll start down my panel to the left of you thinking whether, is that a good or a bad thing? Anybody take it first?
I mentioned it earlier. I think it's a good thing for trademark holders that they don't have to register all the typos, thousands of typos, which they will never use. That's the main benefit probably of the URS. The problem is what will happen after the registration period ends. I mean, they will be available again, the domain names, which have been the subject matter of a URS proceeding. So they will be free for registration for the next cyber squatter. That might be the limitation of the scope of the URS.
But at least you will have the opportunity to look up the cases which were decided. So what cyber squatter will take a domain which was already a topic for a dispute?
Of course, but I mean, we all know these snapping services, yeah, which are on the market, and there's great risk, of course, that after the registration period, all the cyber squatters will register again the domain name which have been the subject matter of the US proceeding. So, what would be the effect then of the US? I mean, the suspension of the domain name will only last until the end of the registration period. I think that's the limit of the effect of URS.
You can extend it, I think, for another year.
Yeah.
But I think, for me, what's interesting about it is where the URS came about, and the objective there really was one of suspension, because it was for that registrant who has 1,000 domain names, which you shouldn't have. And you're taking that 1,000 domain names out in one go quickly, but you don't want to add that to your portfolio, whether you're a 30,000 domain name portfolio holder or you're 100. You really don't want to have those domain names in. So it was crucial at that time. Suspension was the way forward, because you weren't appropriating the property. But then we saw, which Peter will remember this push to saying, well, it should be a transfer, because what's the point of suspending it? It then drops, and we've got all these issues down the line, so we should get a transfer. And there's quite a few different opinions on that, really, in the IP community. My personal view is one of different beasts, UDRP, URS. Keep them different, because if you want to transfer, you use the UDRP. If you want to suspend it, you use the URS. Don't try and morph the URS into a UDRP, and vice versa. So that was my view, but I don't have, a lot of people don't agree with that view, which is why it's just interesting on the, even on the panel, what we think, and in the audience, what you think, because some brand owners are absolutely adamant that that should have been transfer in there, and that a suspension is completely pointless. Other questions? Oh, Jonathan.
David, I just want to make a follow-up point on the previous one, which is just to make sure, given that we've said we'll work at the different levels of the audience, and the question related to the implementation of trademarks getting into the clearinghouse. And in case anyone's in any doubt, getting a trademark in the clearinghouse doesn't offer protection in and of itself. The requirement is still to participate in the launch mechanisms of the different registries as they come to market. So let's say, for argument's sake, there are 100, 200, 500 registries coming to market. Each and every one of those will have a launch mechanism in place that may or may not cost money, and may or may not cost various amounts of money. So there will be a fee and a requirement to get the marks into the clearinghouse. And in addition to that process, there will be a requirement, should you choose to as a rights owner, to participate in one or more of the launch mechanisms which rely on the data in that clearinghouse. So it's very, very important to not think that getting your mark in the clearinghouse, mark or marks or portfolio of marks, is only first base. There are many other bases to cover, and that goes to the other question on defensive registrations as well, and how one might approach that. And then, of course, on to URS and UDRP and all the rest of it.
Yeah, good point, Jonathan. Yep, lady in the middle there. Microphone on its way.
Hello, I'm Bettina Krause. I'm a trademark lawyer as well, and I have the question, maybe not all of these people around here know the differences between the USRP and the URS. Are the same grounds and the same legal proceedings involved? And so it could be mixed up, and you just say use this way or use the other way, or is it just... Then I would answer your question, well, then keep it different. Or if not, then I would say, why don't you make it a choice for the URS? Whether you would like to suspend it and have the same problem again next year, or whether you would like to have a transfer.
I'll maybe let Torsten say a few words on that if you want, about the URS and the UDRP difference, but it was certainly requested that the option was to have suspension or transfer. That's been discussed quite heavily over the last 6 months, 9 months, and it's ended up as, suspension is the only remedy. So that's where it is. Final applicant guidebook. That's where it stays, as far as I'm aware. But Torsten, if I don't know whether you want to mention a little bit about the differences in speed or
the criteria,
grounds.
the substantial criteria are very similar. If you look at the criteria in the applicant guidebook for the URS, you'll see that they are perfectly in line with what panelists have said under the UDRP in thousands of cases. So there's no big difference between the URS and the UDRP as regards the standard. You have to prove that the domain name holder has no rights or legitimate interest, that he has registered and used the domain name in bad faith, and all the examples illustrating these criteria are rather similar to what have been said under the UDRP.
I think the main essential difference is twofold, really. It's the filing fee is going to be a lot cheaper. It's going to be around $300 instead of your $1,500. So that's a big, a big plus. But it's also designed really for clear-cut cases. So it was designed the ones that you look at the domain name, you look at the website, and you go, of course, there's no issue here. If there's any issue of a license or an argument over facts or anything, it shouldn't be URS. Should be a UDRP or court. But that's the thing, it's really so blatant that you look at it and you go, oh yeah, these guys have got 500 of our brands or whatever, each one the same, each are going to this, each doing that. It's so clear you really don't want to be drafting or arguing a UDRP because the chances are they're really not going to reply because it's so blatant. So that's the idea, and hence, you file your trademark, your who is, and you've got a 500-word limit to explain what's going on instead of the 5,000-word limit in a UDRP. And you give a lawyer a 5,000-word limit, he will write 4,999 words. So the 500 words is a very good thing, in my view, because especially for those of us who may be looking at these decisions for $300, of which the service provider will no doubt have some sort of fee, it's not much time to be looking at these sort of cases. So if someone's arguing with 5,000 words, it's not very much time to be looking as a panelist.
I have a question myself. David, you mentioned or made up an example with regard to the confusing similarity standard. And you said Alan and Alan might be similar. Do you have a decision, or do you have an idea of how the panels will decide that case? I mean, that's one of the most important issues, actually. If you consult companies, they ask you, can you tell us how this standard will be interpreted? And the problem is that as a consultant, you usually have a problem to tell them how the panel will decide it, because you only have a few remarks in the applicant guidebook. But there's no case law on which you can rely on, and it's really difficult to predict how the panels will decide. And that's a really important issue for companies who decide or who have to decide whether they will apply or will not apply. That's an important issue. For example, I mean, there are various examples. Bayern, there will be an application for Bayern. Will Bayer AG, the pharmaceutical company, will they be excluded if Bayern will be accepted in the first round and they have not applied? All these examples. There are various other examples. And the problem is that as a consultant, you have really you can hardly predict how the panels will decide it.
No, I completely agree, Torsten. I mean, it's one of those areas that many brand owners are concerned about. And I mean, Olaf's in the room, and this is really one of your specialist areas. Would you like to take that answer and give some guidance on the confusing similarity situation which we have?
Oh, that's a tall order, yes. Because it's not that easy, because when it comes to confusion, it is a human factor thing. So you need most certainly humans to do that. And while you can identifying identical strings, that's comparatively easy. But here you go that it should be that there's a high likelihood of this creating confusion in the average internet mind of the average internet user, if I am quoting the applicant guidebook right, which I may not, rather than just a matter of association between a name or a string and another string, that the first string brings another string to mind. That is, so in order to make it clear that there is a distinction between the two, it should be, to be confusingly similar, there would be a high risk of user confusion. So that's as far as we can say today, and that's where we also need the panelists to really inspect it visually and clearly in order to get to a conclusion, rather than just relying on an algorithm, which is fine to identifying cases of identity. And it could give an indication, but it's really a matter for human judgment.
And
is that helpful?
It does. It all helps. I think, Olaf, I was going to say one thing. If something goes to the panel for them to look at it, do they look at the content and the business plan at all, or is that completely kept away from them? I've got a microphone here. Maybe I'll give.
The string similarity panel will look at the visual similarity only. Second step, if you have a string similarity objection, any aspects of similarity can be taken on board and considered. But in the first, when you have string similarity panel, it's visual only. And it's not considering whether the approaches or the business plans have any similarities or anything of the sort. It's just the strings, whether they are similar or not.
Yeah. Sure, go on.
I think we ended up in a very interesting question, and probably we can make a poll out of it. I think this LL.M is phonetically quite similar, but if you spell it into your computer or into the browser line or something like this, it's completely different. And on the other hand, we have this .Bavaria, .Bayern, and Bayer, which is only, the difference is only one single letter in the word at the end of the probably we can ask the audience, what do you think? Is LL.M similar to each other, or is Bayern, Bayer similar to each other? Just show.
So, double question. So, who thinks .Allen and .Ellen are confusingly similar? 2, 3, 4. My daughter will be very happy. And who thinks it's .Bayer and .Bayern with the one that Bayer, yeah,
chemistry,
and .Bayern are confusingly similar?
Of course.
More so. So who thinks .UPS and .UBS are confusingly similar?
Yes.
So I suppose in conclusion, we'd best be in Ellen's shoes than UBS.
David, I've got one question that if I may, or I think I'm asking Kurt or Olaf if they can help with this one. I talked earlier about getting the marks into the trademark clearinghouse, and there's different thresholds for Sunrise and for the trademark claims service. And then the new TLD applicants are required to participate and use the clearinghouse. Is there no fee or a possibility of fee to rights owners for the trademark claims service, or is that on the part of registry operators to rights owners? That's the bit that because I can see from a Sunrise, you're running a Sunrise, you offer rights owners the opportunity to participate, it's mandatory to work with the clearinghouse, that's clear. There may be a fee to rights owners from the registry operator. With respect to the claim service, is there a fee or not? In other words, is there a guaranteed minimum protection that rights owners get with no additional fee other than submitting their rights into the clearinghouse?
It's on its way, I think.
Can we have the mic over here, please?
So the way it's written now is that the fees are on a transaction basis. So the trademark owner pays a fee to register in the clearinghouse. The new gTLD registries pay to operate a Sunrise and IP claims service. So each registry pays to operate the services for the mandatory services that they're obligated to provide. So trademark,
and therefore might be entitled to charge a fee on to rights owners for that. That's for the claim service, for example, or
I don't. Well, it's not written that way. I mean, it's meant that the registry is supposed to provide that service. That's the way the contract's written.
Mm-hmm. Okay. If there's one last question for the last minute remaining, I do want to finish before schedule, so that I'm get my little gold star saying you moderated this well and you didn't overrun. So one more question.
My name is Erna Eigner. I have a question regarding the use requirement. Is it necessary that a trademark, a registered trademark, is actually being used to be included in the trademark clearinghouse?
Anybody?
Well, there is the same one. Did someone else? No, you go ahead. As I understand it, for the purposes of use in Sunrise, there must be a demonstration of use. And it must have been registered prior to 26th of June 2008. For the purposes of trademark claims, there is no demonstration of use required.
That's slightly different.
Proceeding.
US,
that's the main difference to the UDRP. The US proceeding requires that the mark has been used, that the use is demonstrated.
Yeah. Okay, well on that, thank you very much to the panel, and thank you very much to everybody attending, and I hope it was useful, and you've had a few questions answered, and everything else you haven't answered or had answered, newgtld@icann.org. Thank you.
I thought when we asked about the confusion of those Bayern, we might also add Bayern Munich to the mix, whether that makes it any more confusing. And speaking of Bayern, after lunch we will be hearing from the information delegate of the Bavarian government about challenges and opportunities of the new top-level domains. So we'll be looking forward to that. But Bavaria is, of course, the patron of this conference. So do come back for that after our lunch break. Our lunch break lasts until 1:45. It would be great if everybody could be back promptly at 1:45 so we can get started again. And a very warm round of applause, please, once again, to all of the panelists and to David Taylor for that very thought-provoking discussion. Many thanks.